All right, then let's get some reaction then. For more on this, we are joined via Zoom by political analyst Ongama Mtimka. Very good afternoon to you, sir. Always a pleasure to see you. Thank you for being with us here on SABC News.
Good afternoon, Flo. Thank you for having me.
You're most welcome. Much talk about the CR17 bank statements. I do see you on Twitter commenting on at times about it. I guess we're unlikely then to see them unsealed, given this current judgment that was handed down today by the Crown Court. Your thoughts on what this means going forward? And I'm not yet touching on the issue of the precedents. We'll talk about that later on. But for now, just your thoughts in terms of this judgment that was indeed handed down then today.
Sure. So there were always a number of issues. One, there's the tendency of democracy itself to be captured by commercial interests, which is something that has attempted to be controlled through legislation in different parts of the world. In South Africa, we are new to it through the Political Party Funding Act. But that act is silent on internal party campaigns. And in terms of the political work that still needs to be done, the next thing for Parliament is to look at in what ways can internal party campaigns be looked at as far as legislation is concerned. My issue with this case had always been this, that unless obviously there were acts of criminality, there were always no basis to look into this campaign, precisely because there's no legislative framework that actually gives effect to that kind of action. That democracies are captured by commercial interests is a fact across the board, across all political parties, and all suggestions that political parties made, including ANC factions, to the contrary, were just attempts to actually deny what they know is happening and is a fact of democracy. So it was never going to be the Constitutional Court or the legal processes that resolve that question, because it's something that needs to be looked at in terms of processes of developing legislation. So this decision by the court vindicates the idea that there ought to have been a delineation of scope and recognition that what was frowned upon rightly could not be the kinds of things that get resolved through legal processes, because by their nature, they were political, ethical, and moral issues which have not yet been developed into specific guidelines as far as the law was concerned.
Incidentally, those matters have now, as you've seen, kind of merged into one, particularly if we notice and we take note of what's happened currently with the former President Jacob Zuma. But let's park the issue of whether it was President Cyril Ramaphosa or not for a second. Let's imagine it was any other case. Let's leave the ANC and that CR17 campaign alone for 1 second here. You know, precedent has now been set that the public protector cannot go into the private affairs of internal campaigns, and I mean that to me came across quite broad as that ruling was sort of delivered by Jafta, and I wonder if this could indeed turn out to be a dangerous precedent, and you'll answer me with regards to that, if this could be a dangerous precedent, especially when it comes to matters pertaining to corruption, as we've seen, where sometimes political parties do embroil themselves or entangle themselves in issues of corruption. If it is not the public protector who is to look into these sort of matters, and as as was said in the Constitutional Court, she had no jurisdiction to look into that, then in that case, who then has that jurisdiction? And I hear you talking about developing legislation, and that concerns me. It means that the law is not yet developed in the sense which it certainly should have been developed at this stage. So maybe let's go into that. Let's talk about the precedents. Let's talk about who then has the jurisdiction and how exactly then this should have then been handled when there were questions about you know, the campaign funds or any other party. And remember, I said let's park the issue of President Cyril Ramaphosa for a second. Yeah.
Absolutely. So the good thing here, Flo, is that some of the ground has already been covered through the Political Funding Act. So to the extent that there are violations in future that are going to happen in terms of funding political parties, we're already covered there because there's some basis for investigations, whether on a criminal sense or by the public protector. In fact, the issue there is an issue of scope, that criminal issues get to be investigated by the police. So public protector stumbles on something like that in future, a referral is simply made. Secondly, as far as the funding of candidates contesting within political parties, that's the issue that still needs legislation. Remember that the Constitutional Court or the court system is not a law-making system, even though their decisions are precedent-setting. The law-making institution remains Parliament, and Parliament has got to make the laws that help us, and we must push as citizens, academics, and different institutions that pushed for the Political Funding Act to be approved, to broaden its scope, because we already see that there's already a weakness. So whether it was, say, for example, Nkosazana Dlamini Zuma, there was always going to be a question of to what extent can the investigations go in a framework where there's no, there's no clear law that has been broken, such as, for example, money laundering, because nobody can preclude investigations of money laundering where there's prima facie cases. But where you are just wanting to see something and there's no prima facie case, then that's arbitrary. So we need to get the legislation to catch up with the practice. But by the way, I must say, this is not an ethical argument. This is not a moral argument, because that argument cannot be absolved by the Constitution.
But can I just challenge you, Mr. Mtimka? I just want to challenge you quickly, and I'm sure you can challenge me right back. But obviously, this is a conversation between the two of us. You say that there was no reason as to go into those bank statements. One of the reasons that was raised was due to the fact that the company Bosasa has been named quite significantly at the Commission of Inquiry into State Capture, and there were concerns or questions around whether or not there might have been some of the donors within the CR17 campaign. So that is actually one of the reasons as to why. So if you're saying that there was no reason to go into those statements to begin with, I have to actually challenge you on that one. I wonder if that is indeed correct. There seemed to have been a reason as to why they had to be unsealed. Or do you have another understanding?
Let me explain. As part of a criminal investigation, there's a prima facie case that some crime has happened. I'm sure nothing stops the NPA or any other organization from subpoenaing those statements in order to follow a criminal case. Arbitrarily, you want to look at it just to determine whether a crime has been committed. There, for me, it borders on arbitrary. You should do that for everybody. If you catch somebody doing crime, then you are justified in selecting them specifically to investigate further. If there's no prima facie evidence of crime, and you are out of something that is existing across the system, and you just pick one area, then there, for me, that's tantamount to a witch hunt. Anyway, the point I was making, Flo, is that the president is not absolved from the moral and the ethical question of the campaign. So by virtue of the Constitutional Court clarifying the legalistic argument, it does not mean, for example, the ANC, and this is the argument I've always advanced, the ANC created a sense of false victimhood by arguing that they were precluded from acting because the statements were sealed. They know that it is part of their rules that you should not use private donations. So that allegation was enough for them to actually take political action against the president. The reason why they didn't do it was precisely because they knew that once they trigger that political action, they would be counterbalanced by those internally who knew that that was in fact a rampant practice within the party. So the point I'm making is that we have the president still has a moral obligation to answer questions that we ask. The issue that I'm saying is there's a difference between that and the legal obligation to disclose.
All right, Mr. Mtimka, always a pleasure talking to you. Thank you very much for engaging with us here on SABC News. Much appreciated. All right, that is political analyst Ongama Mtimka weighing in, of course, on the Concord judgment this afternoon.